Good morning, everyone. Welcome to a training on the City of Alameda's Sunshine Ordinance. My name is Sarah Henry. I'm the city's Public Information Officer. And today we'll hear a presentation from Michael Roush in the City Attorney's Office and Laura Weisiger, our Alameda City Clerk. During the presentation, please enter your questions into the chat at any time. And at the end of the presentation, we'll go through all of the questions that we receive. I'd now like to turn things over to Michael Roush and Laura Weisiger.
Good morning, everyone, and thank you for attending this morning. I know that it's mandatory to a certain extent, but I appreciate your being here for the live presentation rather than watching it perhaps at a later time when you might not be able to get your questions answered with live people. The city attorney, Eben Chen, will certainly, he indicated he's going to try to join us later on. He's had some other items to attend to today, but he may join us later on to help out in answering your questions or making part of the presentation. As Sarah indicated, certainly be glad to entertain any questions or concerns that you have as we go through it. Probably easier to do it at the end, but if there's something that you feel you need to have answered straight away during the presentation, let us know and we will handle it that way. Hopefully this will, for many of you, this will probably just be a refresher course. As most of you know, this is mandatory training every 2 to 3 years. So most of you have been through this. And even if you have not been through this, you are probably generally familiar both with the Brown Act and the Sunshine Ordinance. But hopefully this will be a good refresher. There have been some changes to the Sunshine Ordinance in the last couple of years, and we'll reflect that here in this morning's presentation. So let's move ahead. And Sarah, thank you very much. Next slide, please. As most of you know, the Ralph M. Brown Act was amended or was adopted in 1953. And it has stayed pretty much the same over the course of the years. And the most important part about this, of course, is the fact that that the public has the right to know about how the conduct of the people's business is being conducted, and that the actions of legislative bodies, including both elected and appointed officials, should be taken in an open manner and their deliberations conducted openly. There's a very general proposition set forth in the ordinance and in the statute, which indicates that the people of this state do not yield their sovereignty to the agency which served them. The people have the right to know what's going on and be informed so that they can retain control over the government that they have created. Next slide, please. In addition to the Ralph M. Brown Act being embodied in a state law, in November of 2004, a proposition was added to the California Constitution, Proposition 59. And it basically embodies what is in the Ralph M. Brown Act, put it into the Constitution, which gives it a higher status, as it were, than just a statute. And that would be, it's important because if for some odd reason the state legislature decided to cut back on some of the rights or obligations under the Brown Act, you still have this constitutional amendment which would take precedent to make sure that it's clear that the people have the right to continue to have access to information concerning government, and that meetings of public bodies will be open, and that writings shall continue to be public records and available for the public. Next slide, please. Clearly, one of the most important aspects of the Brown Act, also embodied in the Sunshine Ordinance, we'll talk about in a moment, is that all meetings of the legislative body shall be open and public, and all persons permitted to attend this meeting, except as otherwise provided in this chapter. And we'll talk about some of those exceptions in a minute. The Sunshine Ordinance that was adopted by the City Council in 2012. It's been amended from time to time, but basically it clarifies and supplements the Brown Act and the Public Records Act. For the most part, the Sunshine Ordinance tracks what's in the Brown Act. There are a few exceptions and where the Sunshine Ordinance is more restrictive, and we will talk about those in due course. Certainly the Brown Act and the Sunshine Ordinance has very, very broad coverage. It applies to every type of local government, whether they're elected or appointed. This includes the city council, the boards, commissions, committees, etc. Um, Meetings are subject to the Brown Act and the Sunshine Ordinance, and they're not just limited to face-to-face meetings. They include any kind of communication media, such as telephone, computer, text messages, social media apps. And again, we'll talk a little bit about those in a few moments. In addition, the meetings include uh, remote locations by teleconference. That has been somewhat modified in light of uh, the emergency caused by COVID-19. And we'll talk about that. Meetings, I just want to talk a little bit about what constitutes a meeting. And a meeting is a congregation of a majority of the members of a policy body, whether, again, this be the council, boards, or commission, and they meet together at the same time and place. That's considered a meeting. But there also could be a meeting where there would be a series of gatherings, each of which might involve less than a majority of the public body to hear, discuss, or deliberate upon any item that's within the subject matter jurisdiction of the particular body in question. And again, as indicated here in this slide, a meeting um, could also include or involve some type of medium of communication by telephone, or more likely by text messaging, or by email, etc. Next slide, please. One of the key elements of both the Brown Act and the Sunshine Ordinance is the right for the public to participate in the meetings. And this includes not just individuals, lobbyists, news media. Everyone has the right to attend, record, broadcast, and participate in the meetings. In order for that to be accomplished, there needs to be a meaningful agenda provided in advance of the meetings for two reasons. Number one, it will limit the discussion and the action that is going to be taken on the agenda. In other words, the public needs to know what's going to be discussed, and only those things that are on that agenda can be discussed. And secondly, by making materials that are relevant to the agenda item available to the public, it enhances the right of the public to participate meaningfully in that discussion that's going to go on by the policy body. Certainly, legislative bodies, boards, and commissions may adopt reasonable regulations on public testimony and the conduct of public meetings. As for example, if you are conducting a public hearing and there would be an item that has 30 or 40 people who want to speak on the item, and Laura can certainly testify that this does happen from time to time because you have a very engaged community here in Alameda, and they turn out to want to be heard, have their voices considered by whoever's hearing the matter. And certainly, if each of those individuals were allowed to filibuster, to talk on for 10 or 15 minutes, meetings would drag on, or not drag on, but they would go on for many, many hours. And so as a consequence, councils and the boards and commissions typically will adopt regulations that say, okay, we have this many speakers, we're going to limit it to 2 or 3 minutes each. And that is usually adequate time for a person to get his or her message across to the council. Certainly ahead of time, people can submit written comments if they need to have more time to get their views across, and that way all the information that a council can consider at the meeting can be understood and considered. Next slide, please. As we've indicated, the Brown Act applies to all legislative bodies. They're called policy bodies under the Sunshine Ordinance. And it applies to the governing body, city council. It applies to appointed bodies, to boards and commissions. It also applies to standing committees. Standing committees are committees that are formed through a number of different ways, but they're intended to be more or less permanent in nature. Laura, could you identify a couple of standing committees that the City Council might have?
The City Council has a couple of agencies they meet with jointly. So such as they meet with the school board. So there's 2 council members and 2 school board members that meet, and they're a standing subcommittee of the City Council and another agency. And that's the same with there's also one with the hospital board and then one with the East Bay Regional Park District. Hopefully that's the type of example you were looking for, Michael.
Thank you. And again, these are committees that go on indefinitely. They do not have a limited purpose. And while the various committee members may change from time to time, those committees are subject to the Brown Act and the Sunshine Ordinance, and we'll talk about some of the particulars of that, what that means. Contrast the standing committee to what are called ad hoc committees. Ad hoc committees, back up for a second. Standing committees consist of less than a majority of the particular legislative body. So if you had say the council has 5 members, a standing committee would be 2 members of the council. An ad hoc committee, by contrast, is a committee that is created for a very limited purpose. It has sort of a function that's going to go on for a relatively short period of time. It's limited in what its intent and purpose is, and it does not have to comply with the Brown Act or the Sunshine Ordinance, although the Sunshine Ordinance does say an ad hoc committee may require or may have the same kind of agenda and noticing requirements as a standing committee, but isn't required to do so. And also the staff, the Brown Act and the Sunshine Ordinance applies to staff, both in terms of receiving training like we're doing today, and also in terms of making sure that the staff does not become involved in what's called a serial meeting, and we'll talk about that in a moment, whereby the staff would somehow facilitate or cause there to be a meeting in contravention to the Brown Act or the Sunshine Ordinance. Next slide, please. There are different types of meetings. There is the regular meeting. These are the meetings that typically the City Council or the boards or commissions set up so that they know when they are going to meet on a regular basis. For example, the City Council typically meets on the 1st and the 3rd Tuesday of each month, and they set that through a resolution, and everyone sort of knows that that's when the council is going to meet. There are also special meetings. These are meetings that occur outside of the regular meeting time. And again, there's agendas and there's certain noticing requirements about special meetings. And we'll talk about that a little bit more here in a moment. Emergency meetings may come up as a result of a civil unrest or some other kind of unexpected situation that might occur. And in those types of situations, the regular types of agenda and noticing doesn't have to occur. So in other words, it allows the council to deal with situations that evolve unexpectedly. Adjourned meetings are simply situations where, let's say you are at a regular meeting and it's getting very late in the evening or early in the morning, and sometimes decisions are not well made at that time of day or night, and therefore the council may adjourn that meeting to a specific time and place in order to complete the business at hand. Next slide, please. There are some exceptions to what constitutes a meeting. Certainly, one of the exceptions would be individual contacts between a public official and any other person. Certainly, public officials need to be out in the community to hear what people have to say about issues that are going on with the city. And therefore, a public official can meet with the public, advocates, consultants, news reporters, staff, or a colleague, another person on the board or commission or the council, as long as it's not a quorum of that particular body. Next slide, please. And additionally, a majority of a legislative body can attend a conference or a similar gathering that's open to the public that addresses issues of general interest to the public. For example, the League of California Cities, now it's called Cal Cities, they hold an annual conference every year, typically in the North one year and the South the following year. And generally, or often, a majority of the council will attend that particular conference in order to learn about what other cities are doing. And there's programs and seminars put on at that. And it doesn't prevent, it certainly allows a majority of the council to attend those type of conferences because, again, those conferences are open to the public and they address issues that are of general interest to both the public and the public agency. Next slide, please. A majority of a legislative body may attend an open and publicized meeting of another body of a local agency or a legislative body of another local agency, as long as while they are attending that meeting, they do not discuss among themselves, other than as part of the scheduled meeting, the business at hand. So, for example, let's say that there was a planning item that the Planning Commission had considered. It gets appealed to the City Council, and a majority of the Planning Commission, Planning Board wanted to attend that meeting. They would certainly be allowed to attend that. They would be allowed to be heard about the matter because it is a matter that is within the specific nature of the Planning Board's jurisdiction. Next slide, please. I mentioned a moment ago standing committees and the fact that standing committees themselves are required to have an agenda, have it noticed, etc. But from time to time, what happens if, again, let's say there's two members on the standing committee. What happens if another member of the legislative body or the rest of the body wants to attend a meeting of the standing committee? That is permissible under the Brown Act and the Sunshine Ordinance. However, the caveat is you can attend, or the member can attend, but they are not allowed to speak. They can only be there as observers at that standing committee. So while it may be a meeting of the standing committee, it would not be considered a meeting of the legislative body as a whole. Next slide, please. Certainly, a majority of the legislative body may attend a social or ceremonial event. Let's assume that someone is getting married and they have invited the whole council or a majority of the council to attend. Certainly, there's no prohibition on the majority of the council attending such matter. But again, they just cannot discuss any city business while they are there. They have to be simply there to enjoy the event and not to conduct any business. Next slide, please. This is a fairly new topic concerning communications outside a meeting using an internet-based social media platform. Certainly, the use of social media platforms is very common. And the concern was, well, what can happen if I'm a council member or a board member and I use social media? Do I run afoul of the Brown Act or the Sunshine Ordinance if I do that? And the state legislature adopted some modification to the Brown Act, consistent, I think, with what the Sunshine Ordinance teaches, that does allow that to happen, but there are certain caveats to that. So, for example, if a legislative body member is using social media platforms, it may answer questions from the public, member of the public. It can provide information, or it can solicit information from the public regarding a matter that the city council or the board member is within the subject matter jurisdiction of that particular body. The caveat here is, though, that a majority of the members of the legislative body may not use the platform to discuss among themselves business of a specific nature. and that a member who uses the social media platform shall not respond directly to any communication on that platform that is posted or shared by any other member of the legislative body. And discuss among themselves is defined in this particular statute to include the use of digital icons that express reactions to communications made by other members of the legislative body. So let's assume a legislative body member is using Facebook or some other social media platform and makes some comment about something that is within the subject matter jurisdiction of the city council. Another city council member looking at that cannot, put a like or a thumbs up in response to that. They're certainly, looking at it, they're observing it, but they are not to respond in any way, and that includes using any kind of digital icon to express a reaction to that communication. And again, an internet-based social media platform is a platform that is accessible to the general public, and that is allows members to participate free of charge, and it doesn't need the approval of the person or entity. A person or an entity cannot be blocked from using that social media platform. So there are certain restrictions in terms or limitations in terms of what constitutes a social media platform. Next slide, please. These exceptions do not permit a majority of legislative body to meet together with staff or with other members of the body in advance of the meeting for a collective briefing. That those kind of things would involve a majority at the same time and place, and that would constitute a meeting. And if you're going to have a meeting, it must be open to the public and satisfy other requirements of the Brown Act and the Sunshine Ordinance. Next slide, please. From time to time, you will see where the City Council has scheduled a retreat or a workshop. Essentially, these are meetings. They can be characterized as retreats or workshops, and these are permissible. But again, these retreats or workshops must be noticed. There must be an agenda that goes along with them, and they must be open to the public. Next slide, please. Often, our office gets questions about whether or not there has been what's called a serial meeting. Serial meetings are not permitted under the Sunshine Ordinance or the Brown Act because, again, they involve a situation where a majority of the legislative body is meeting, as it were, outside of a noticed regular agenda or meeting outside of a regular noticed meeting with an agenda. Often what happens is that there is a communication that takes place either between council members or legislative body members and either staff or other members of the legislative body. And by using what's called serial meetings, there can be a discussion and consensus reached about an item that is taking place outside of a meeting that has otherwise been open to the public and for which there's been an agenda. Next slide, please. Typically, two types of serial meetings occur by either what's called a daisy chain or a hub and spoke sequence. In the daisy chain scenario, member A contacts member B, discusses where member A, what member A's feelings or position is on a particular item. Member B then contacts member C and communicates either what member B feels about it and or relates what member A feels about it. Member C then contacts member D, etc. And suddenly now what has occurred is that a majority of the legislative body has had discussion and may have reached some sort of collective concurrence or understanding, and all that has taken place not yet a meeting that the public's been invited to. And that can happen in a number of different ways. For example, it can happen with email, and that's why we have always informed council and boards and commissions that if you happen to get an email from a from you get an email, do not reply to all, because by doing that, you set up a situation where the information is now being shared by the majority of the legislative body, and that can run afoul of the daisy chain scenario. The other typical kind of serial meeting is what's called the hub and spoke. And that involves, for example, a staff member being the hub, let's say, of the communication, and other members of the council or the commission. Uh, Everybody's getting the same information, and by doing that, the information ends up being a decision or a concurrence is reached by a majority of the legislative body, and that is occurring outside the regular noticed and agendized meeting. Next slide, please. Technological conferencing. Some years back, the legislature recognized that there could be the use of technological advances, teleconferencing could be used in order to allow a person who might otherwise be absent from a meeting to participate in that meeting. And so therefore, the Brown Act now allows this type of teleconferencing situation. I'm going to talk a little bit about what has happened sort of post COVID-19, because that has changed somewhat. But before the regulations applicable to the COVID-19 and other types of emergencies have occurred, what would have to happen is that if a member was going to participate in the meeting through teleconferencing, we can go to the next slide on this, please. They would have to the agenda would have to indicate that there's going to be a teleconference location, and it would have to give the full address of where the council member was going to be. And that would include, for example, if a person was going to be at a conference and would be at a hotel, the agenda would have to indicate the hotel's location and the hotel room. Or if the person were ill and were going to be at that person's residence, the agenda would have to provide that person's residence. And in addition, that location must be accessible to the public and have a speakerphone in order to allow the public to participate. And then all the votes would have to be by roll call. Obviously, this is a little clunky. And as a practical matter, when there was teleconferencing, because a council member would be absent and would be at a hotel or at their residence, I'm not aware that members of the public are going to be at the hotel or at the residence to participate, but still required for the agenda to be posted there, and that somebody, if they were there, would have to be allowed to participate. Next slide, please. Certainly, I think, as most of you are aware, that there have certainly been now exceptions to what I just discussed about the teleconferencing situation, because of the concern that when there's a declared state of emergency, when health officials have imposed recommended measures to promote social distancing, and when the legislative body has determined that meetings in person would present imminent risk to the public health or safety, meetings can now be conducted remotely, as it were. And that's certainly what we've been dealing with since March of 2020. Whether, most likely come the new year, there may be some hybrid situation of this. For example, people may be able to attend meetings in person, but also there may need to be the opportunity for people still to call in remotely. But in any event, we'll see how that plays out. But even now, because of the remote conducting of meetings, the agenda has to provide notice to members of the public how they can attend by either a call-in number or again by an internet-based service option. Legislative bodies currently have to make certain findings every 30 days in order to continue using these procedures. Otherwise, though, all the provisions of the Brown Act and the Sunshine Ordinance apply. You still need to have an agenda, still need to have notice. Members of the public must be able to participate fully in the process. Council must deliberate in public, and then the votes are all taken by a roll call vote. Next slide, please. We've been talking about agendas, and as most of you know, for every regular meeting, as well as the standing committees and also special meetings, there must be a posted agenda that advises the public of the date and time of the meeting and the matters to be transacted or discussed. There are certain requirements, and this is again where the Sunshine Ordinance is different than the Brown Act. Under the Brown Act, all that's required for a regular meeting is 72 hours notice, although typically most cities give a little bit more time than that. But 72 hours is all that's required, and for a special meeting, only 24 hours. But under the Sunshine Ordinance, there has to be 12 days notice before a regular meeting of the City Council. And for all other appointed bodies, planning board, etc., 7 days notice is required. And the must be an agenda, and the agenda must have a meaningful description of each item to be transacted or discussed at the meeting. In other words, if the agenda does not provide sufficient information so that a reasonable person reading it can understand what it is that's going to be discussed or transacted, that would be a violation of the Brown Act and the Sunshine Ordinance. Next slide, please. The agenda shall indicate all the items of business and a statement of what the item is going to be discussed. It must specify the time and location and be posted in a place that is accessible. Typically, this is on the city's website, city's cable channel, and available at the public library. Next slide, please. And it's important that the agenda itself have a meaningful description, but certainly the meat and bones of the agenda item are going to be embodied in the documents that are material to the agenda item. Typically, this would be the agenda report, resolution, ordinance, backup information. And those documents must also be available 12 days ahead of time with the complete agenda packets for each body posted on the city's website, library, and in the clerk's office during normal business hours. Next slide, please. From time to time, City Council, as well as other boards and commissions, may call for a special meeting. At special meetings, you are limited to the business that may be transacted. Only those items on the special meeting agenda may be discussed. Written notice must be sent to each member, but typically that is waived, but you need to notify, for example, newspapers and radio or television station that you're going to have a special meeting. And again, here, as I mentioned before, there has to be at least 12 days notice before the time of the meeting. There's certain exceptions if you have an urgency or an emergency matter beyond the control of the city, but most times, if there's going to be a special meeting, it must be noticed at least 12 days ahead of time, including having all the agenda materials available for the public. Next slide, please. As indicated, from time to time, there could be adjourned or continued meetings, and if that is the case, those are adjourned to a time and place specified in the order of adjournment. And if no time is stated, the meeting is continued to the next regular meeting. Next slide, please. There is also a place on every agenda for for an item, well, before I get there, typically you cannot take any action or discuss any item that is not on the posted agenda. There are 3 exceptions to that, and that can be a situation where there's an accident or a disaster or a workforce disruption or some other issue that causes a threat to public health and safety. Then that can be discussed even though it's not on the agenda. There's also a situation where an item, let's say, arises after an agenda item is posted, but action must be taken on the item before the board or commission or the council is going to meet again. In that case, and really this doesn't happen very often, but when this does occur and there's a need to take action on it, 2/3 of the members of the legislative body can add the item to the agenda and can discuss and take action on it. But from time to time, I know we'll get a question about, well, we didn't get this on the agenda because it kind of fell through the cracks. Can we add it? And the answer is no, you cannot. It's not an emergency or not an urgency just because someone forgot to put the item on the agenda, and the item would have to be postponed until the next regular agenda can be posted. There's a third exception where the item appeared on agenda previously, but was simply continued from that meeting and held not more than 5 days earlier. Next slide, please. Certainly at every meeting, there's an opportunity for the public to be heard, and what should be the response of the legislative body to such comments. The public can talk about anything that is not on the agenda. Typically there are two places on an agenda that give the members of the public the right to be heard on an item that's not on the agenda, but the council or the legislative body cannot take action on or discuss that item that's not on the agenda. Generally, what happens in that situation is the legislative body can either ask that the item be put on a future agenda, or often refer the matter to staff to get back to the person who raises the item, so that that person knows that the item is just not being dismissed, but a staff member will get back to that person and see where the item then would go. Next item, please. As we've certainly discussed, the public has the right to review the agenda and agenda materials so that they understand what it is that's going to be discussed and perhaps decided by the legislative body. Next slide. I think, as I've mentioned, there has to be a place on every agenda for members to speak on items of interest. And in addition to the meeting open to the public must be allowed to speak on any item that's on the agenda. And this includes consent calendar items. So, typically there is a number of consent calendar items that the council would adopt by one motion. But if a member of the public wants to be heard on that, the item can be removed, as it were, from the consent calendar item and placed on the regular agenda, so that the member of the public can be allowed to speak on it before council takes action on it. Next slide, please. There are certain exceptions to the council meeting and discussing items in public, and these are called closed session items. And these exceptions are limited, but they're important. Certainly, one item that allows the council to meet in closed session outside of the public's review is litigation, whether it's anticipated litigation or pending litigation. This is so that the council, for example, can have a free and full discussion with its attorney, and the attorney, obviously, it's a confidential communication, can lay out both the pros and the cons of potential litigation or pending litigation. And certainly you would not want to have that discussion where the other side's attorney was sitting out in the audience and hearing what you were saying. So that's why you have closed sessions on this. But any final action on litigation must be reported out at that same meeting. Similarly, on real estate negotiations are limited to price and terms. And again, this is a situation so that the council can give direction to its real property or real estate negotiator in terms of what particular acceptable price and term should be if a property is either being sold or perhaps purchased. And again, you wouldn't want to have those kind of direction given in an open session. And any final action on those real estate negotiations have to be reported out in open session. Certain personnel matters are also can be conducted in closed session. Typically, these are for hiring, dismissing, evaluating, and disciplining people or employees that the city council has control over, or such as the city manager, city attorney, city clerk, etc. And again, action on this must be reported out at the same meeting. Another exception would be labor negotiations. The city obviously has negotiations with a number of different unions and associations, and wants to give direction to its negotiator in terms of what might be acceptable situation for both salaries and other benefits. And those kinds of negotiations need to take place in a closed session rather than in the open. But again, any final action on that does have to be taken in open session. Next slide. Also, there's some other closed session items that come up from time to time, although not very often. Public security, for example, if the city were going to undertake certain situations to make City Hall more secure, that kind of discussion obviously should not take place in an open session. City's part of a number of joint powers authorities, and sometimes the joint power authority will be involved in litigation, and the discussion that would need to take place in closed session to give direction to the members of the legislative body who are on the joint powers authority. Certain investments of the city's pension funds, responses to certain state audits, and the reviewing criminal records of certain license applicants also can take place in closed session. Next slide, please. The next part of this is on public records, and I will turn this over to our city clerk, Laura Weisiger. Laura.
Thanks, Michael. So public records are another aspect of what is open to the public. This public records are covered under the California Public Records Act, which is separate from the Brown Act, but it's another statute in the state government code. And there's also federal laws on this as well. And the city of Alameda has seen an increase, like many other cities, in the number of public record requests we are receiving. Fortunately, the city has purchased a software in order to help us deal with this and keep us on track and get us responding to them. So we have a portal on our website now called Next Request, where people can submit requests, and everything is then posted publicly, and other members of the public that might be looking for the same thing can see it there. For the city's records, the city clerk is considered the custodian of records, and the city manager does designees for the police department. The custodian of records is responsible for meeting certain timeframes. And the first time frame is you're supposed to inform the requester if there's any records within 10 days. And the really nice thing about Next Request is it lets you know the due date and gives you reminders and keeps you on track with that 10 days. And then if you see that there's it's going to take more time to process the request, you can ask for an additional 14 days and extend that due date by those 2 weeks. And sometimes there's even extremely complicated or involved requests. Like we've been getting a lot of email searches that have thousands and thousands of emails that we have to produce and go through, and so those type of records take even much longer. So what we do with those types of cases is we let the people know, we will exceed the 14 days and we will produce them by this time, or expect to have them all completed by a specific time. There are certain supplements to the Public Records Act in the Sunshine Ordinance as well. And one of those things is that they, if people request it electronically and we have it electronically, we have to provide it electronically. And most are electronic these days. So we usually have all electronic records. So here's some of the unusual circumstances that can require the city to take a longer time to respond. If they're like stored somewhere and you have to go and access them and get them out, that could take a while. If they're extremely voluminous and have very many records you have to go through, you could have to maybe consult with another agency and work with them to see what records you've shared and figured out how to get those from them. And then sometimes you can even maybe finance is a good example. Sometimes you can even have to write like some kind of program or something to pull the data out of like the spreadsheets or the budget or something like that, or the business license database. And so you could maybe need extra time to do something like that. Hopefully most record requests staff can just respond to directly and get the person on their way with what they want to see. And that is it for the Public Records Act. But we are really excited about next request, and we really hope it serves the public better, and we hope it helps staff as well. So I will send it back to Michael, where he's going to go over some other details about things that are pertinent to this topic.
Well, before we get into that, I want to indicate that under the Sunshine Ordinance, there is a complaint procedure. And the complaint must be filed within 15 days after the alleged violation. And then there would be a hearing before the Open Government Commission. The Open Government Commission is a commission that is set up by the Sunshine Ordinance to hear complaints about alleged violations of the ordinance, and generally, or when practical, when people are available, to have that hearing within 30 days. And the commission then is to issue a written decision affirming or rejecting the complaint. Next slide, please. If there's a violation of the public access to meetings, the commission may recommend to the originating body steps to cure or correct that violation. And the originating body is to make a final decision whether to accept or reject the commission's recommendation. And typically, the status quo should be maintained if possible, pending a final decision by the originating body. If there's a violation of the public information, public records, for example, the commission may recommend to the city steps to cure or correct. The appropriate city staff, whether it's a city clerk, city manager, etc., is to consider the commission's recommendation and then inform the city council of the final decision. When these things do come up, violations, the city website is to provide a listing of the commission's decisions and outcomes of any cure or correct recommendations. Next slide, please. Conflicts. From time to time, there will be what are called conflicts of interest. Conflicts of interest are situations where a member of a legislative body has a financial or other type of conflict which prevents them from participating, which sometimes prevents the council itself from making a decision. Sometimes it can just result in the individual member not being allowed to participate. And the idea is that if, in a particular case, if a member of the body has a financial interest in it, it puts them in a situation where they have both an obligation to their financial interest and an obligation to the city as a member of the legislative body, and that puts them in a conflict. Under the government code, section 1090, this applies to any contract that the city council itself might make. So if you have a member of the legislative body who is financially interested in that contract, the council itself could not enter into that contract. For example, let's say you had a contract would come before the city council to award a construction contract, and let's say a member of the legislative body was the president of that particular construction company, In that case, even though it may have submitted the lowest bid for the project, the city council could not award that contract to the construction company because the member of the legislative body would be financially interested in that contract. And if for some reason it fell through the cracks and the contract was made, it would be considered void, and the construction company would literally have to disgorge any funds it received back to the city. And the member of the legislative body cannot cure the situation by recusing him or herself as a blanket prohibition against the council as a whole. Next slide, please. Contrast that with the conflicts of interest that occur under the Political Reform Act, which is a state law. This applies to government decisions. Basically, if it's a situation where a public official has a conflict of interest that is likely to have an impact on his or her financial interest, even though the contract itself may not be in front of the city council, but as an outcome of that decision, the individual member's financial interest would be impacted. What usually happens is the council member would have to what's called recuse him or herself from the decision. Take for an example, let's say that there was a subdivision, some development project going in a particular part of town, and a member of the public, a member of the legislative body lived within a certain distance of where this project was going to go in. And under most circumstances, if they're within a certain number of feet, there's a presumption that it's going to have an impact on that person's financial interest, cause their property values to go up, down, whatever. In that particular case, because of that potential conflict of financial interest, the council member would have to recuse him or himself from participating in the decision, and the rest of the council would then make that decision. Next slide, please. There are also common law conflicts, and the common law basically prohibits public officials from placing themselves in a position where their private personal interest conflicts with their official duties. It can be a broader, it's a broader conflict prohibition than just either under Section 1090 or under the Political Reform Act. But again, it doesn't preclude the policy body from making the decision, but the member must recuse him or herself from the decision-making process. Next slide. Often, when these kind of conflict issues come up, whether it's 1090, Political Reform Act, or even common law, generally we encourage persons who feel they may have a conflict to contact the city attorney's office to get some legal advice in terms of whether the person should or should not participate. We can provide advice, but that advice, no matter which way it goes, does not provide protection against enforcement if the Fair Political Practices Commission, its administrative arm, decides that there was a violation. Any advice that we may have provided to the member about whether it may not have been a conflict will not provide protection. The only protection that can be provided is that if the member gets written advice from the Fair Political Practices Commission and then acts on that advice, if for some reason there might be a change of heart by the FPPC, the written legal advice would provide protection to that member. Next slide, please. From time to time, we are asked about whether our advice can be shared with other people. What's called the attorney-client privilege. Attorney-client privilege is an evidentiary rule that protects communications, confidential communications between an attorney and a client from disclosure to third parties. The idea of confidential communications is to allow there to be this relationship between clients and their attorneys so that there can be a full and open discussion of facts and tactics surrounding legal matters. As to the city attorney, the client is the city, as embodied in the highest authorized officer, employee, etc. Accordingly, confidential communications between the city attorney and the city council as a whole are privileged, or between the city attorney and city employees generally are privileged. Again, though, I think what has to be kept in mind, not every communication that the city attorney provides either to the city council or to individual city employees is privileged. The communication has to be of a confidential nature, and that really deals with facts and circumstances involving legal matters, and not just sort of what I would consider to be routine items, but really is intended to make sure that there can be a full and open discussion between the city attorney and the person or the body that the city council, that the city attorney is providing advice to. Next slide, please. Somewhat akin to the attorney-client privilege is what's called attorney work product. Attorney work product, again, is a statutory provision that allows attorneys to prepare cases for litigation or for legal advice, and being done with privacy so that it encourages them to look at both favorable and unfavorable aspects of the situation and provide that advice to whoever it is that they're advising. And certainly, otherwise, if that work product was able to be discovered, as it were, by the other side, that would allow the other side to take undue advantage of the city attorney's work in terms of providing both favorable and unfavorable aspect of the legal issue. The doctrine provides absolute protection to writing that reflects an attorney's impressions, conclusions, opinions, or legal research or theories. Next slide, please. We want to look for just a moment at the role of boards and commissions. We've sort of focused on the council here, but obviously boards and commissions are a big part of city business. And boards and commissions, their jurisdiction is typically set by charter or ordinance. There are a few boards that are established by charter. Most commissions are set up through ordinance. They generally lack subpoena power. They have the power to promulgate rules to govern internal operations. City staff usually sets the agenda in consultation with the body of the board or commission and its chair. And again, boards and commissions are subject to oversight by the council, meaning that the council appoints and the council can remove. Next slide, please. City council and staff rely on the boards and commissions to make advice and provide advice and make recommendations on matters that are within their subject matter jurisdiction. And some bodies, such as the planning board, has quasi-judicial decision-making authority, and sometimes it's final quasi-judicial decision-making authority as well. Next slide, please. That concludes the presentation. Certainly, Laura and I will be glad to answer any questions. I don't know whether Mr. Shen has been able to join us, but if he has, I'm sure he will be glad to chime in if anyone has any questions as well.
Thank you, Michael. Thank you, everyone. You can continue to post your questions into the chat and we will go through them. I have about 10 right now, but we have plenty of time to get through all of the questions. So keep posting it into the chat. And we'll start with the first one, which is that someone asked if the slides will be available after the meeting. And yes, we're going to post both the slides and the recording. So that's an easy one. Second question, I think for you, Michael, can a commission continue to chat once the meeting recording has stopped? Oh, you're mute. Oh, no, you're not muted. You're right there.
Yeah. I would advise no. It's certainly possible that those kinds of chatting may have nothing to do with the subject matter jurisdiction that the policy body has been discussing, but you run the risk that it either could be part of that, or someone could certainly think that it's part of that. And so therefore, I would advise that once the recording stops, that everyone leave the meeting, as it were, and not have that sort of off the record discussion, because it's too easy to kind of run afoul of what the Brown Act and the Sunshine Ordinance otherwise allows.
Great, thank you. Next question. If staff emails board members and they reply all and say something, is that a violation?
So for example, if say the city clerk sends out a notice to the city council saying, are you all available to meet in a special meeting on January 20th, 2022? That type of, and again, ideally, I would recommend that you not reply to all, but simply reply individually to Laura, because number one, it's just good practice to do it that way. But I would say in that particular kind of matter, because it's not a substantive thing, it's really just kind of a meeting setting situation, it would not be a violation. But there may be other situations where a staff member may send out a substantive issue to all of a board member or a council member, and a reply to all would certainly lead itself to a potential collective concurrence about that issue, and that would violate both the Brown Act and the Sunshine Ordinance. So again, refrain from the reply all button and just hit the reply, safer.
In that case that you just mentioned, what would be staff's obligation if somebody did reply all and it was substantive?
A gentle reminder not to do it in the future, I think, would be sufficient. I mean, I think people, I mean, we all do it, and we do it inadvertently, because that's typically what we do with email when there's a number of people on the string. So again, what I typically do, and I think most staff members do as well, is just remind the person who hit the reply to all, that's, be careful with that. Try not to do it in the future.
And
Got it.
Sarah, I'll add
Yeah.
on that one thing I like to do when I send out the email to a board or commission, especially because the council's pretty well trained, is I like to put in the email, please do not reply all. So that's one trick staff could use, is to, as you're sending out the email, just do the reminder ahead of time, and maybe it'll prevent it.
Yeah, a comment just came in saying that they put in every email to commissioners not to hit reply all. So sounds like a very wise tip.
Well trained, well trained.
Next question. Please explain the separation between AMP and the Alameda City government regarding meetings between PUB board members and city staff, city council members, any Alameda City charter restrictions, that kind of thing.
Repeat that again, please.
Sure. Explain the separation between AMP and the Alameda City government regarding meetings between PUB board members and city staff with council members with regards to any Alameda City charter restrictions, etc.
AMP is AMP is part of the city. The charter does set up did create a public utilities board, which does have certain oversight with respect to the AMP facilities, or the AMP operation. Alan, are you on this call at all? Alan Cohen? I don't know if he is or not. Alan is the one who advises the commission or the board. He's not. Okay.
He's not.
All right. And he might be able to answer the question a little more specifically. Certainly, the AMP board certainly is going to meet with, with its staff, and the attorney from the city attorney's office. But that board, like any other board, is subject to the Sunshine Ordinance and the Brown Act, and its agenda has to have an agenda, has to meet all their noticing requirements as it does any other board or commission of the city. They do have some opportunities to meet in closed session, just because of the nature of what they do. But ultimately, they are responsible, like any other board and commission, to the city council.
Oh, great. Someone wrote that they are forming an ongoing advisory committee consisting of staff, regional stakeholders, and community members who advise on projects but don't make decisions. Their understanding is that the Brown Act doesn't apply. Can you please speak to where the line is for this?
It is true that many boards and commissions may not have the final decision-making process or the final decision-making authority as as the city council does. But under the Political Reform Act, decision-making is more broadly defined to include any type of board or commission which makes which either provides advice or makes recommendations to the final decision-making authority, and whose recommendations and advice over time are typically followed. So I would say that at least in my experience in Alameda and elsewhere, city councils typically do adopt the recommendations generally of its boards and commissions. And so therefore, and I've advised other boards and commissions in Alameda that even though they may not be the final decision-making authority about, say, setting fees, for example, under the Political Reform Act, they are still considered a decision-making body, and therefore the Political Reform Act, as well as the common law conflicts, apply to them. And therefore, if a board member would have a financial interest in a decision before that board or commission, he or she must recuse him or herself from participating.
In this case,
Yeah, I can maybe add something here. I think that one of the distinctions they might be looking for in this question is if it's a council formed body
right.
versus a staff formed body. And I think that's maybe the line they were talking about is, definitely if the council, appoints a bunch of people to a group and they form that body, that's the legislative body forming another body. If staff is putting together some stakeholders to get some input and maybe even provide them information out to help spread it out that way, that would be a staff formed one. And I think that's maybe the line they were talking about. Maybe.
I think so. Yeah, definitely.
Very good distinction, and certainly from time to time, staff will meet with stakeholders, and those stakeholders may come up with a recommendation that they would like to see the city council do. That, and staff may have a different opinion, and certainly in that particular case, the council is going to be well informed both of what that stakeholder committee or stakeholders would like to see and staff's reason as to why that recommendation may not be followed, and staff's recommendation. So that is a good distinction that Laura raises there. Thank you, Laura.
Thank you. Next question is asking, are social media posts subject to Public Records Act requests?
Say that again, please.
Are social media posts subject to Public Records Act requests?
This is an ongoing and evolving situation, I think Laura can testify to. I think the answer is if there is social media posts that and for which there has been a Public Records Act request, and if those social media posts involve subject matter jurisdiction that a particular person is, that's within that person's subject matter jurisdiction, then arguably it is subject to the Public Records Act. Now, again, what would have to happen is that there would be a request made of the individual to review his or her social media and to provide that to the city clerk and the city attorney to review to make sure there wasn't some exception as to why that information or document should not be disclosed. But if that social media post is not otherwise exempt under the Public Records Act, and if the social media post dealt with a subject matter jurisdiction that is within that member's, under that member's jurisdiction, then it probably would be disclosable.
Okay.
And I think one thing to note is this recently came up at an open government commission, and the city does have control of some social media posts, and the city's social media posts that we have control of, we would definitely produce, and we would have access to those and know about those. And then, that people's outside ones we would have to request, like Michael said.
Next question, if an ad hoc committee is appointed by a legislative body, does it then fall under the Brown Act?
I was looking at the Sunshine Ordinance this morning, and it does provide a policy body, which is subject to the Sunshine Ordinance and the Brown Act, shall not include an ad hoc committee unless such committee was established by charter or by ordinance or resolution of the city council. Typically, in my experience at least, that ad hoc committees that at least formed by the council, and I think by the planning board as well, are not done pursuant to charter, ordinance, or resolution. It's simply something that the chair or the mayor might appoint or create by motion, as it were, or not even necessarily by motion, just that the mayor has the discretion to set up, for example, ad hoc committees. In that case, under the Sunshine Ordinance, such ad hoc committee would not be considered a policy body, and therefore the Brown Act and the Sunshine Ordinance does not apply to it.
Here's just a comment. Somebody commented during the presentation that having to post their room number on an agenda does not feel safe if with regards to that.
I'll just jump in on that comment, Sarah, that the city council has currently still passed the findings in order to continue the teleconferencing. And that matter will go to the city council again on January 4th for them to consider another 30-day time period of that. So, at this point in time, those disclosures aren't required because the city council is making those findings.
Lara, here's a question for you. Is there updated language that staff should be including on the commission board agendas with the current noticing during a public health meeting?
Yes, so it's now AB 361, and it's at the top of all of the agendas, and it also cites the government code section. So that was sent out once it changed from the governor's executive order into that. So if anybody needs that language, you can pull it off the council agenda. You can shoot me an email, whatever you need to make sure you get that correct language on there.
Great. And one more for you. How do we manage a request that spans multiple departments in next request?
So the requester, if they're an outside requester, can only assign it to one agency. Internally, we can assign it to as many departments as we want. So it is possible. The confusing part, I think, is to know when to close it. So if your department has responded and you're done, you could add a note, my department's finished, and there's internal notes field that you can add that. And so then I've kind of been monitoring those. And then if I see that all the departments have responded, then we can close it out. So yes, it is possible, and we're still all getting used to it and working on it. And hopefully we'll get all those kinks worked out.
Great. Next question. Can you briefly go over what should be redacted from public records request?
Generally, what we look at is whether or not the information contains, for example, attorney-client privilege communications, or perhaps in some cases attorney work product. Those are often the case. Sometimes there are also, for example, there's specific exemptions under the Public Records Act for certain police investigative documents. That is somewhat in a state of flux right now in terms of trying to determine exactly what is and what is not disclosable. We're looking, of course, to case law to help provide information and guidance on that issue. And there's also a balancing test that we look at as to whether or not the public's right to know or the person's right of privacy is clearly outweighed by the public's right to know the information. So there's a number of specific exemptions under the Public Records Act, and then there's the general balancing test. I think the city attorney's office tries to take a very tries to go with the intent of the act. And unless it is clear that there is an exemption to not provide the information is going to be disclosed, even though, you know, sometimes the information can be embarrassing. I know we all do emails that where we say things that are a little flippant or a little caustic. That information, that doesn't exempt the information from being disclosed. That's why, you know, one should always, you know, before you send out an email, you know, take a second look at it to make sure that if this ever was disclosed to the public, is it going to, you know, reflect poorly on either you or the organization?
And if I could just tack on to the end of that one, you know, I would always recommend that departments seek the advice of the attorney's office if they have any questions about what should be redacted. And the city attorney's office should always probably be involved in all the redactions. And one thing that our sunshine ordinance requires is that we disclose why the reason for redaction and cite that. So it's a little more tricky, and definitely always good to get the help of the attorney's office.
All right, next question. When a community member emails staff with a copy to the entire city council, what is the protocol for responding?
I can maybe, do you want me to try that one first, Michael?
Please.
So if it's on an agenda item, I will, and I get copied on it, I will always include it in the council record so that all that correspondence that comes in is added to the record. If a staff member gets it and sees the clerk's office wasn't on it, we would totally appreciate you forwarding to us. The protocol that I use for responding is I acknowledge it. I always let them know it was received and will be included in the record so that they're aware. You know, even any document that comes in is always a public record, but it's just nice to make sure that they know it's been added to the record. And I think you know, council members sometimes also individually respond to those, and you know, that's between them and their constituents, but those are also all still public records. But anything that's to the entire council, it's especially on an agenda, it's great to have the clerk's office get a copy.
Great. Next question. What is your take on employees or council members using personal email accounts to conduct city business?
Similar to, well, first of all, I would advise that not occur, just because if it's going to be city business, I would hope and encourage council members, staff members, board members, whatever, not to use personal email for that purpose. But it can happen. I recognize that. And so what then happens is, if there would be a Public Records Act request concerning that, the person would have to look at his or her email account and then inform the city clerk and the city attorney's office whether there were such emails that did deal with city business, and provide those to us for us to take a look at in terms of whether or not they would be subject to some exemption from disclosure. Otherwise, they would have to be disclosed.
Got it. Okay. And then lastly, the Mayor, Marilyn Ezzy Ashcraft, she just made a comment that she'd like to extend her huge appreciation to all of our board and commission members for their service to our city. Very grateful for all of the work that folks do. So thank you. And with that, I didn't have any other questions come in. So back to you, Michael and Laura.
I want to thank everyone for their time this morning. I appreciate your attention to these, and your questions were very, very good. And I hope we've answered them adequately. If not, send your questions in again, or additional questions into Sarah or Laura, and we will get back to you on that. And again, thank you all for your time. I appreciate it very much.
Thank you.
Thanks, everyone. Have a great day.